the legislature, though he is not member of the Lok Sabha and Rajya Sabha. Like those two are the houses. Next, coming to the functions. Functions of the legislature. Okay. The functions can be broadly classified into like legislative functions, executive functions, financial functions, power to amend the constitution, judicial functions, electoral functions, and miscellaneous. That is the other functions. Okay. In detail, we will discuss all those functions of the legislature. Coming to the first one, that is legislative functions. What is the legislative functions? Actually, it is the primary function of the parliament. The legislative function is the primary function. What is it? To make laws for the government, for the governance or government of a country. For any country, the primary function of parliament is to make laws, making of laws or public policies. It is the main function. Okay. The exclusive power to make laws like on the subjects related to union list, residual lists, and with respect to some part of concurrent lists are overridden by parliament. All these powers have taken by parliament only. In the state legislature, we will have the state list. Okay, but here coming to the union list, residual list, and the concurrent list, some of the concurrent list parts are the main functions of the legislature, public policy making. In public policy making, see if there is any conflict between the laws made in the concurrent list, then the laws made by the parliament will become into force. Like if there is any conflict between those central and the state, then the law made by the parliament will come into exist rather than the states made law. It is with respect to the concurrent list only. Other than concurrent list, that is like residuary powers and union list, the states should obey and follow the parliament. That is the central laws or parliament laws. Next, coming to executive functions. Here, what is executive? Like the Constitution of India, in which the executive responsible to the parliament for the policies and what we call programs or acts. Here, the executive is responsible to the parliament for the effective implementation of the programs or policies or acts which is planned by the legislature. Okay, here the parliament can exercise control over the executive by how? Through some of the parliamentary procedures we have seen in the parliamentary procedures. That is through the question hour in the parliament. There will be like some specific procedures, like through question hour in the first session and 0 hour and no conference motion, etc. These three are the major one, which is the parliamentary control over the executive. Here the ministers will be the collective responsible to the parliament. In general we have already talked about it. Okay, in general the ministers are collectively responsible to the parliament, but in particular the ministers should be collective responsible to the Lok Sabha. Keep it remember. Okay, the council of ministers are collectively responsible to the Lok Sabha. Next, all these members will enjoy the conference as long as they enjoys the majority members in the Lok Sabha. If there is a majority members only, they will enjoy the confidence. Otherwise, no confidence motion will become and dissolution of the Lok Sabha will be taken place. It is one of the main executive functions of the legislation. Next, coming to financial functions. Coming to financial functions, here the parliament is considered as the custodian of the national purse. Like the government can collect here Government can collect taxes or levy taxes only with the prior permission of the parliament. After rules and regulations made by the parliament only, the government can collect the tax and make expenditure. Okay. Next, there is no tax can be levied or collected without by the approval of the parliament. Okay. The financial policies of the government, every financial policy, that is everything, the financial policy of the government should be enforced. It can be enforced only after what we call the bill passed by the parliament only. Everything related to financial matters of India is after passed in the parliament only, then it will be implemented by the government. Here, the most of the financial powers of the parliament are mainly exercised by the Lok Sabha only. Okay, the main functions like really the real powers are mainly exercised by the Lok Sabha. And one more thing, the money bills. The money bills can be introduced only in Lok Sabha. Okay, money bills cannot be introduced Rajya Sabha. It should be introduced only in Lok Sabha. Afterward, the bill is passed, then it is passed to Rajya Sabha. Within some few specific days, the bill must be passed. The recommendations given by the Rajya Sabha may or may not be taken into consideration by the government. Okay, or by the Lok Sabha. Next important function, that is power to amend the constitution. We all know that we have till now 105 constitutional amendment acts. Okay, all these acts are the exclusive power of the legislature only. Okay, through or like what we call through which article means article 368. Okay, the union parliament only enjoys the power to amend the constitution only in accordance to the provisions of article 368. So if a bill has if a bill for amending the constitution can be introduced in either houses of the parliament, just remember money bill can be introduced only in Lok Sabha. But if the if there is a power to amend the constitution, for amending the constitution, a bill can be introduced in any house of the parliament, that is the Lok Sabha or Rajya Sabha. Here, the power of amendment is basically of two types, that is majority of the special majority and simple majority. Okay, coming to like most of the part of the constitution that can be amended by the union parliament comes under the special majority only. Okay, then like special majority and special majority with consent of the half of the state's legislatures. Okay, it is the third type. First one, simple majority. Second one, special majority. And third type is special majority, but with consent of the half of the all state legislatures. See, this third category can be taken place when the policy impacts the whole state, the federal system, the federal nation of the state. If it is impacted, then half of the state's concern must be taken into consideration. Okay, example GST. For implementing GST, half of the state's legislation have been approved. Okay, this is related to power to amend the constitution. Okay, power to amend the constitution relates to Article 368. These are of three types: simple majority, special majority with the concern of half of the state legislature. Just these points keep in mind. Next, coming to judicial functions. Okay. See, some of the functions, judicial functions have been given to the legislature. Like, what are those? Like, it is about to increase or decrease the number of judges in the courts. See, whether to increase the judges of the court or whether to decrease the judges of the court, and make laws necessitating the efficient discharge of duties by the judges can be taken as functions of the legislature. Okay, but here the parliament sits as a court of law for investigating the conduct of their own members. Okay, the legislature is competent to deal with cases that cases or breach of their privilege or any other court of law complement to examine them an oath and decide about their punishment with respect to members only. That is with respect to the members only. Like for example, the parliament can impeach the president here, okay, for any violation of the constitution. Okay, next, it can also remove the vice president, the president, the vice president, like the chief justice and the other justice of the high court and supreme court and chief election commissioner and chief and comptroller and auditor general. All these are constitutional bodies. Okay, these can be, these people can be impeached. Okay, all these people can be impeached by the parliament if they violate any rules which are mentioned in the constitution. Okay, these are some of the judicial functions. Next, coming to some of the electoral functions. Here, electoral functions means just like the members of the parliament will participate in the election of the president and vice president. Okay, just remember here the election procedure of the president and vice president. In the election procedure, the members will participate in it, and they also elect the members like speaker and deputy speaker. This is respect to the Lok Sabha. And coming to Rajya Sabha, in Rajya Sabha also, the members of Rajya Sabha will elect their deputy speaker. Okay, here deputy chairman, sorry, deputy chairman. The chairman of the Rajya Sabha is elected by the Lok Sabha only. That is vice president. Vice president is the chairperson of the Rajya Sabha. Whereas coming to deputy chairman, the deputy chairman is elected by the members of Rajya Sabha. Okay, just keep it in mind. Don't confuse in those both things. Next, coming to miscellaneous functions. What are the some other miscellaneous functions means? Like to change the borders of the state or to make the national policies or to approve the ordinances issued by the head of the state or to establish or abolish the legislative councils of any state, then approve or disapprove an emergency proclamation made by the president, or to provide a common high court for two or more states, or to pass laws required for the enforcement of the international treaties. Okay, just remember these points. Like to change the boundaries also, like Telangana and AP has been divided through the Article 3, like that. These are the main functions of the legislature to make national level policies. Okay, to make national level policies or to make ordinances, to approve the ordinances. When the houses are not in session, then president will give ordinances, and these ordinances must be approved by the parliament. Okay, then to establish or to abolish the legislative council, we need to approval from the parliament. Okay, to approve or disapprove an emergency, that is national emergency, proclaimed by the president. Okay, coming to next, common, to provide common high court also. These are some points respective to the miscellaneous functions. Coming to next one, the executive. See, legislature, we had three bodies here: legislature, executive, and judiciary. Okay. Legislature will formulate the policies. Main function, the primary function is to formulate the policies or acts. Here, what is the main function of the executive? Executive is the important branch, like which is responsible for the implementation of laws. Okay, for the implementation of laws and policies. First one is to like policy making. Second one is policy implementation. What this is? Okay, all the policies which are adopted by the legislature is implemented by the executive. Okay, here coming to executives, like different countries or different what you call various designations have different type of works. Like some countries have president, while some other countries have chancellors. With respect to their country, their features are different. Here, the executive branch is not just about the president, prime minister, and ministers. It should extend to the all administrative hierarchy. Administrative hierarchy means it should be consisting of civil servants, who is known as permanent executive. All the civil servants who is known as permanent executive, they will work under the supervision and control, like supervision and control of political executive. See, here the permanent executive. Who are the permanent executive? The permanent executive are the civil services. Okay, these civil services are part and parcel of the executive. Okay, in executive we have president, prime minister, council of ministers. Okay, all these will supervise and control the permanent executives, whether the works are correctly implemented or not. Okay, next, coming to what are the main or important functions of the executive. Okay, here the important functions can be classified into these types, like for formal policy formulation, like for implementation of policies. Next, third one, financial functions. Next, fourth one, judicial functions. Next, fifth one, making of appointments. Next, sixth one, formulating foreign policies. Next, seventh one, defense, war, peace functions. All these functions are primary concern of the executive. Okay. See, formulation means with respect to the what are the policies framed by the legislation. Okay. Here, policy formulation also mean that like through delegated legislation, they will formulate some policies. Okay. And the legislature delegates some of its lawmaking powers to the executive. See, we have some laws implementation law policy formulation policies for the district collector also. Okay, they are also civil servants. They are the permanent executive. Okay, um, these powers are mostly based on the powers given by the legislature. Okay, they are drawn power from the legislature. They will not have the absolute powers. Okay, they have the legislature power, delegated power. If at all the legislature thinks that the power is to be given to the civil servants, then they will allot that power to the legislatures. Next, coming to implementation of the policies. Okay, it is the we all know that the primary function of the executive is to implement the policies formulated by the legislature and to maintain law and order in the state. The primary function, we all know that the primary function is to implement the policies and to maintain law and order in the state. Okay, each government deport here the each government department is responsible for the implementation of the laws and policies concerning to it. Okay, and these are the some of the functions with respect to the implementations of the policies. Next, coming to financial functions. What are the financial functions? See here, one of the most important function of the executive is like acting as an custodian of all finances. How how it will be act as custodian means it has the power to impose a tax, to reduce a tax, or to eliminate a tax. Okay, just remember the executive will have the power to reduce a tax, to impose a tax, and to eliminate a tax. But see, actually, what here absent like happen means the executive exercises a number of financial functions like responsibility to prepare budget. In that also, it proposes to it proposes like the levy of new taxes or charges, the tax structure and administration. Okay, here the executive also collects the revenue and incur the expenditure sanctioned by the legislature. It does not have this thing, does not have any autonomy. See, all the policies implemented by the legislature will taken care by the finance, by the executive. Okay, these are the main function financial functions. These are the main financial functions of the executive. Next, coming to judicial functions. Okay, judiciary has the right to grant pardon to criminals. We'll know that under the system of administrative adjudication, the executive agencies have the power to hear and decide cases involving in some kind of particular field of administration. Here, the total system is not taken into consideration. Some particular field of administrations with under the administrative adjudication, the executive agencies will have their power of judicial functions. Okay, just remember some functions they will be having or allocated. Next, coming to making of appointments. Here, all the major appointments are made by the chief executive. For example, the president of India appoints, we all know that the president of India appoints the chief justice and the other judges of the Supreme Court and the High Court. Next, ambassadors also, ambassadors, Advocate General of India, members of the Union Public Service Commission, governors of the state, even chief election. All those members are elected by the or appointed, not elected, sorry, appointed, are appointed by the executive. That is the chief executive. Who is the chief executive? The president. President is the chief executive. Next, coming to formulation of next point, formulating foreign policies. Okay. See, we all know that it is the responsibility of the executive to formulate the foreign policies, to negotiate, to make negotiations and treaties with other countries in accordance with the national and international law. See, the foreign policy should formulate within the regulations of national interest and international law. Okay. Next important point is defense, war, and peace functions. Okay. Coming to this defense, war, and peace functions. See, this is also like to defend and preserve the unity and integrity of the country and to protect the sovereignty of the country, like it is the like, and also in the event of external aggression or war. It is the main important function of the executive to look into all those of matters. These are some of the important functions with respect to the executive. Next, coming to the type of the types. What are the different types of the executives? Okay. What are the types of the executives? Here we have the political executive, the permanent executive, the nominal or titular, and the real executives, the hereditary and elected executives, single and plural executives, parliamentary executives, presidential executives. Okay, all these are different types of the executive. We will deal in detail with respective to them. Okay, coming to the first one, the political executive. Who will come after the political executive means it consists of the elected representatives. The elected representatives means the representatives which are elected by the people, and they are responsible for the all the decisions and the policies to the public. Why? Because they are elected by the people. So they are responsible to the people. Here, the political executive acts as a temporary executive. Who are the permanent executive? Civil servants are the permanent executive. Here, the political executive will act as a temporary executive. Why? Because it changes for every 5 years. So they are called as temporary executive. What are their main function? The political executive main function is to formulate policies and get these policies and programs approved from the legislature. Then, after making some changes in the policies, thereafter, these policies and laws of the states are implemented by the civil servants or looked after by this political executive. It is the main function of the political executives. Okay, political executive is but politicians. Next, coming to permanent executives. Here, permanent executives, we all know that just how told about. Permanent executives consists of the civil servants from lowest to the highest level. Like they carry out the day-to-day functions. They must be politically neutral. What are their main what is their main job is to carry out the laws and policies of the government without any political considerations. Okay, without any political considerations, they should like implement the laws and policies of the government. Okay, why they are called as permanent executive means they will be in the office or in the chair until they get the age relaxation, that is the superannuation. They will get the regular salaries or fixed salaries, and they are hierarchically arranged. Okay. They are called as permanent executive. Next important one, nominal or titular and the real executives. We all know that there will be two executives, that is nominal and the real. What is mean by nominal or titular? Means they have their power but not autonomy. Who is the nominal or titular means he is the head of the state, that is the president. He is the nominal executive. Who are the real executive means prime minister headed by the council of minister. Why they are called as real executive means all the decisions given by the real executives should be implemented by the nominal executives. That is, the real executive means the council of ministers headed by prime minister. Nominal or titular head means the governor. Okay. Here, the all powers are legal powers of the nominal executives. But in practice, these are exercised by the real executives. Okay, just remember this point, nominal and real executives. Next, coming to hereditary and elected executives. What is it means? Hereditary executive means when the executive assumes office by the law of hereditary succession. They are called as hereditary executives. Okay. When the executive is directly or indirectly elected by the people for a fixed period, is called as elected. Those who are elected is called as elected executives. Those are hereditary through birth, through their father. Then it is hereditary. For example, in Britain, in Japan, and in Malaysia, there are hereditary chief executives. Whereas coming to India, USA, Germany, and many of the other countries, we having elected chief executives. Okay. Then the other type is single or single and plural executives. What are those single and plural executives? See, single means when all the executive powers, see, keeping this, all the executive powers are in the hands of one person, then it is called as single executives. Okay. Examples. What are the example means? India, Britain, USA, France, and many other countries. And many other countries are having this chief, sorry, having this single executives. Okay. How means all the executive powers like are exercised are under the president. Likewise in US also, all the executive powers are with the president of USA. Coming to the plural executives. Okay. Plural executive means plural members. Like when the executive powers are vested with group of the members or in a committee or in a council or a commission. And all these powers must be exercised by all the members of the committee. Okay, all the members of the groups or all the members of the groups. Then this type of executive is known as plural executive. For example, we have in Switzerland, Swiss, all the executive powers are vested with federal council. Okay, here in federal council they have 7 members. Just remember, France versus India. France. Here, France means federal council. It is plural executive. Okay. Next important type is parliamentary executive. Okay, parliamentary versus we can also call it presidential. See, how can we say it is parliamentary or presidential means based on the relationship between the legislature and the executive. If there are separation of powers, then it is presidential executive. If it is what we call collective, if it is collective, then some through some checks and balances, then it is parliamentary. Okay. See, in parliamentary, the members of the political executives is individually and collectively responsible to the legislature. Okay, the legislature can be dissolved by the executive here and presidential executive. We are just discussed. Presidential executive means separation of powers between the executive and judiciary. Okay, here the executive is not responsible to the legislature. Neither they are, they cannot, neither they can dissolve nor remove the others. Okay, it is one of the main difference between the presidential and parliamentary executives. Next, important, that is judiciary. Okay, we had discussed about the legislature and executive. Now we will discuss about the judiciary. We all know that the legislature will make the policies, the executive is to implement and look after the policies, and the judiciary is to interpret the laws and whether the laws are correct in nature, whether the laws are implemented in accordance to the constitution. This will be looked after by the judiciary. Okay, judiciary, like it settles the disputes and administers the justice. What is the main function means? An impartial and independent judiciary. Independent judiciary is like most important condition for a civilized government. Unless there is autonomy and independent judiciary and impartial, we cannot succeed the judiciary implementations. And the judiciary should be also should act as the fair and uniform, and it should be structurally and hierarchically organized well. Like we all know that here in India we had a structure. Coming to the structure, we had that high court, so Supreme Court is the highest court of appeal. Then we had the high courts, then we had the district courts sessions. So like that we had the clear hierarchy. Okay, coming to the structure, we all know that Supreme Court is the apex body, followed by the high courts. Then this high courts is followed by the district courts, and then we had the subordinate courts. Okay, see, where there is single and integrated hierarchy, the courts from top to bottom deal with the disputes arising under the laws enacted by the Union Parliament and as well as the State Parliament. All the laws made by the State Parliament and the Union Parliament will taken by the single or hierarchical integrated hierarchy judiciary. Okay. Why it should be independent means in order to safeguard the constitution. We all just discussed about it. Like how we can embody independence means through appointment of judges, through security of tenure, through the method of removal. All this make them as independent. Through independent, they can safeguard the constitution. Okay, just coming to the appointment of the judges. Here, we all know that the Supreme Court judges are appointed by the President of India. Appointment of the office of Chief Justice of India, like should be senior most judge of the Supreme Court. Who is the senior most of the Supreme Court means he should act as the Chief Justice of India. Here, the Union Minister of Law, Justice, and Company Affairs would seek the recommendations of the ongoing the Chief Justice of India. Okay, who is ongoing Chief Justice of India's recommendations will be taken into consideration for the next appointment of the next Chief Justice of India. Here, after the recommendation given by the Chief Justice of India, the Union Minister of Law, Justice and Company Affairs, he will put up the recommendation to the Prime Minister, who will advise the President in the matters of appointment. Okay, here see the structure. First, the Union Minister of Law, Justice and Company Law, then Prime Minister, then President. Then we have, then this he selected the Supreme Court, Chief Justice. Security of tenure. Coming to security, the Chief Justice, we know that the judges and the Chief Justice of the Supreme Court will be provided with some security of tenure, means the age limit. Like age limit is for 65 years for Supreme Court and 62 years for the High Court. Like the president cannot be removed, the president cannot remove them unless the grounds are mentioned in the constitution or until they get the age of 65 with respect to Supreme Court or 62 with respect to High Court. This is with respect to security of tenure. Next, method of removal. What is the method of removal? Means the Supreme Court judge can be removed from the office only by an order of the president. Okay. In India, the judges of the Supreme Court or High Court can be only removed on basis of only two criteria. What are those two criteria? Means based on misbehavior, based on proved misbehavior and incapacity. Based on those two grounds only, the judge of the Supreme Court can be removed. And this must be followed by the each house majority, that is by special majority. Each house has to pass a resolution by a special majority, and this resolution is addressed to the president, who then issues the removal of the order of the removal. First, it should be addressed to the president, and then it is issued to the order of the removal. Those are with respect to the structure, appointment, security of tenure, and method of removal. Next, coming to some important functions. Functions of the judiciary. We can see here, what are the important functions of judiciary? That is, first one, administration of justice, appellate jurisdiction, creation of judge-made law. Next, guardian of means guardian of the constitution. Next, protector of fundamental rights. Next, advisory functions. Next, non-judicial or administrative functions. Next, extraordinary jurisdiction. All these are the functions of the judiciary. Here we will deal in detail with all these points. Coming to the administrative, we all know that. What are the primary function of the judiciary means? The primary function of the judiciary is to apply the laws to disputes. When the dispute is brought before the court, then it determines the facts which are involved in the dispute. Okay. Then the court determines the facts through evidences given by the contestants, and by applying the appropriate law to the dispute or the case, the court awards judgment. The judgment can be imposed a penalty or punishment to the guilty. This is what administration of justice, how administration is with respect to justice. Okay. Next, coming to appellate jurisdiction. Here, the Supreme Court has the jurisdiction of hearing the appeals. Okay, high appeal means what? Like which are against the judgment of all high courts of India. If if any high court or other courts give against the judgment, then they can directly go to the Supreme Court through appellate jurisdiction. In case of any civil dispute, if the High Court thinks that the intervention of the Supreme Court is required to solve the query of law, then then the case will be decided by the Supreme Court. Here, some specific civil cases are also dealt by the Supreme Court. If at all the High Court does not have any what we call authority. Then, third important point: creation of judge-made law. Like there are many cases where the judges find it difficult like to select an appropriate law for the application. Then or the law may not be clear, or two laws might conflict under the given circumstances. Then we see the creation of judge-made law. Here the judge decide what the appropriate law is on the basis of their wisdom and common sense. Okay, based on their wisdom and common sense only, they will make the appropriate law. Why? Because they both may be contradictory or conflict in nature. Okay, then it is called as like judge-made law or a case law. Here, then the decisions taken generally regarded like as bounding on the later judges also. In the similar cases, like if at all the same case or the similar type of case is coming to the other type of judges, then it is binding on the judges also to implement the same law. That is called as codification of laws. Codification of laws means they will codify the laws. One law is implemented to the every state. Next, guardian. Guardian of the constitution. How it acts as guardian of the constitution. We all know that most of the federal countries like India, like in India or in USA or in Australia, the highest court, that is the Supreme Court, act as the guardian of the constitution. How? When the conflicts of the jurisdiction between the central government and the state government, or between the legislature or the executive, all these are decided by the courts. So through this, if there is any violation through executive or if the executives or if the legislature violates any provisions related to the constitution, then the courts will declare them as unconstitutional or null or void. Okay, null and void and unconstitutional by the judiciary. Okay, this is known as the power of judicial review. Okay, how it acts as the guardian of the constitution means through judicial review. Here, the judicial review safeguards the powers of the states and ensuring balance between the union and the states. Okay, just remember that it safeguards the powers and safeguard the powers of the states. Next, protector of the fundamental rights. We all know that fundamental rights are protected by the courts. The judiciary protects the rights of the people against the what we call against the encroachment of the executive or any other associations, whether it's associations or individuals or the executive. If they take away the fundamental rights, then the judiciary protects by keeping those rights to the individual. How the Supreme Court enforces the fundamental rights means through the writs. Like the writs are habeas corpus, mandamus, certiorari, quo warranto. All this comes under the writs. Through this only The judiciary protects the rights of the people and acts as the protector of the fundamental rights. Next, advisory function. Okay, we all know that advisory function of the Supreme Court. Like whenever the president seeks the opinion of the Supreme Court, like on matters related or on the question of law or fact of public importance, whether in question of law or fact of public importance arises, then the president seek the opinion of the Supreme Court. And on any matter arising out of pre-constitution treaty or agreement, also the Supreme Court may give the opinion. In the first case, it is mandatory and binding of the Supreme Court to give the advice. In the first case means the question of law or fact of public importance. Public important matters, in public important matters, the Supreme Court must give the advice. Coming to second one, that is pre-constitutional treaty or agreement, the Supreme Court may or may not give. It is the judiciary discretionary power to give or not to give the advice. Okay, if at all, in second case, the judiciary give that advice, it is in the hands of the president to implement it or not. It is advisory function. Next, judicial, non-judicial, and administrative functions. Like courts also perform some other miscellaneous functions of non-judicial in nature. Like the courts may grant certain licenses and administrate the estates like property of deceased persons and appointment receivers. They also register marriages, appoint guardians for minor children and lunatics. And Supreme Court also give power to exercise control over subordinate courts and their officers and servants. That is delegated legislation or judiciary legislation. Delegated legislation, we call it as. Next, coming to extraordinary jurisdiction. Extraordinary jurisdiction. Okay, what is this extraordinary jurisdiction? It means the Supreme Court to hear any appeal related to any matter for which the court and tribunal had to decide the judgment through the option of special leave petition. In case of tribunal related to armed forces, in okay, with respect to armed forces only, this extraordinary judicial will take place. Like, and also the Supreme Court has power to like withdraw or transfer any case from High Court to High Court or High Court to Supreme Court. And also some extraordinary power, like the Supreme Court has the authority to review any verdict. Like it can give the verdict against which is given in the earlier verdict. Like Supreme Court is defined as court of record because with the rights to make punishment for the contempt of the court. It is also called as extraordinary jurisdiction. Okay, these are extraordinary jurisdiction. Next, okay, now we will just revise what we have learned, some of the important points. We all know that like the central government will divide it into three major ones, like the legislature, the executive, the judiciary. In the legislature, in that is the Indian Parliament, which is the main component of the in Indian Parliament. The main component is the legislative branch. In the legislative branch, we had two houses. That is one Lok Sabha, two Rajya Sabha. Lok Sabha is called as the House of the People. Rajya Sabha is called as the House of the State or Council of the States. Why? Because it is elected by the states representatives. Here, House of the People means it elected directly by the people. Okay. Hmm. Here the legislature make the laws and policies. Okay, this is related to legislature. Next, executive. Like we all know that it is the second important organ of the government. Its main function is to like to implement the laws and to look after the what we call the laws are implemented correctly or not, like to carry out the policies and programs or laws to maintain law and order are the important functions of the executive. Yep, the executive also we have the political executive, permanent executive. We have learned about it. Permanent executive means civil servant, and the political executive means the politicians, which will be in 5 years of term. Next, third important organ is the judiciary. Here, the judiciary maintains and promulgates law and order of the country. Like it interprets the laws. If at all the law is like inappropriate to the constitutional laws, then it will be declared as null and void or null and void, and it is declared as not will be implemented. It will also solve the disputes related to government of India and one state, or government of India and two or more states, or between the two or more states. All these disputes will be taken by the judiciary and will be solved by the judiciary. Okay, these are some of the important points relating to Unit 4. The next class, we will discuss Unit 5. Okay, thank you. If anyone has doubts, yes, you can ask me. Okay, then, thank you. Thank you all.